Hello everyone, myself Advocate Gautam Harshwal working at Lexis and Company Law Firm as a junior associate. So today in this video, I am going to discuss with you section 125 of CRPC, which is a very important topic, which is a very important section to discuss. A case was being filed before Bombay High Court. What the case was, I am going to discuss with you in this case. Let's start our discussion without any further delay. So, maintenance under Domestic Violence Act cannot be compared with refusal to maintain under Article 125 of CRPC. Bombay High Court had said that in this case. Why so? Let's find out in this video. So, the Aurangabad bench of the Bombay High Court recently opined that provision of maintenance under the Protection of Women from Domestic Violence Act 2005, which is DV Act in short, is different from the concept of neglect or refusal to maintain under section 125 of Code of Criminal Procedure. Justice S.G. Meher opined that section 125 deal with refusal to pay maintenance or neglecting to maintain. However, there was no provision in the DV Act to test refusal and neglect to maintain. The tests to prove the domestic violence and refusal and neglect to maintain are different. There were no provisions in the Domestic Violence Act to test the refusal and neglect to maintain. The concept of domestic violence is specific as provided by DV Act. It could not be compared with the concept of section 125 of Code of Criminal Procedure. The order stated that the observation in this case came in a petition challenging an order of a session court directing a husband to grant maintenance to his wife after she basically made an application under the DV Act before a judicial magistrate. The magistrate in this case had rejected her application. Why so? Why he rejected that? He said that holding that the pleadings and the deposition made by the wife before the court did not match. That's what he said that. And further, the Sessions Court upheld this order. However, the session judge considered the case as if it were an application under section 125 of CRPC, held that the husband refused and neglected to maintain the wife and granted the maintenance. And this was challenged by the husband before the Bombay High Court. The High Court noted that the Sessions Judge had minutely scrutinized evidence to conclude and affirm the finding of the magistrate court that there was no domestic violence, owing to which the wife was not entitled to monetary relief under the DV Act. Justice Meher also reiterated that a wife could simultaneously claim relief under the DV Act as well as CRPC. However, the wife had failed to plead that the husband had refused and neglect her. The Sessions Court cannot travel beyond the pleading and laws involved in the case, considering the concept of refusal and neglect and granting the maintenance to the wife in DV Act case is out of jurisdiction and exaggeration. The orders of Session Judge is illegal, erroneous and improper and liable to be set aside. That's what the court, Bombay High Court has held that in this case. So the decision of the Session Court has been set aside by the Bombay High Court. So what is your opinion regarding this? Do comment, let me know in the comment section, and till then take care, bye bye, see you in the next video.